Hi,
Uh,
Ashu. Welcome to our webinar. Thank you so much for agreeing to do this. This webinar is about the basics of criminal law. Before we get started, why don't you tell us a bit about yourself?
Hi, Shashi. Thank you so much for this opportunity. I have been in this profession, the legal profession, for around 14 years now. 2018, joined Aditya Advisors as the partner.
Mhm.
And since then, we are doing litigations, primarily corporate litigation, including some of the
Okay, so before I ask you about the questions about basic criminal law, I wanted to ask you a very important question that everyone has been wondering. Since we're in the midst of Corona and we're in the midst of a lockdown, I was wondering what happens if you actually break the rules of a lockdown, like if you don't abide by the curfew or don't abide by any of the rules that have been set up. What are the repercussions that could happen?
That's an interesting question. The First of all, I would like to tell you that in Indian law, there is no reference of the word lockdown.
Mm.
Lockdown is a method or is a word being used by the government officers
Mm.
so that people know that there is a restriction in movement of goods in a free space except for the essential commodities.
Mm.
However, as per Indian law, there is no word called lockdown. In lockdown, of course, police can't arrest a person without warrants or without directions from the competent court. But yes, the governments are imposing certain sections along with lockdown. And if one breaks those sections, then of course, police has the power to arrest them.
What kind of sections would that be referring to?
I'll just refer to the Indian Penal Code for that.
Oh,
Disobedience of order duly promulgated by public servant.
okay.
If
And
the public servant says that, look, so and so area is restricted, and people it's that order, then he has the power. Under this section, he gets that power to arrest that person.
okay.
Then there is a section. It basically negligent act likely to spread infection of disease dangerous to life, which is of course the COVID-19 or coronavirus, whatever.
Mhm.
Malignant act likely to spread infections of disease dangerous to life.
So under these sections, someone can be arrested if they don't abide by the lockdown.
Yes, correct. Because under lockdown, the word lockdown is a phrase being used to express, but
Mm,
it's not been defined in the law.
mm.
So while imposing lockdown, these sections are also invoked.
Okay, okay, that makes sense. That makes sense. So I think we would advise everyone to just follow the rules and stay at home to stay safe. Okay.
Correct.
So then we'll go back to some of the basics of criminal law, which is why I'd invited you for this webinar. This is basically to give the layperson a basic understanding of criminal law. My first question to you is, what is the meaning of FIR? If you can tell me.
FIR is the first information report.
Mhm.
But if you see, as such, the word FIR is not being mentioned anywhere in CRPC. But FIR is basically the first information which either the victim
Mhm.
or the witness
Mhm.
goes and give to the police.
Mhm.
If it's a cognizable offense
Mhm.
or a non-cognizable offense,
Mhm.
police has to register a complaint. Then they start their investigation. The FIR is primarily the first information which a public servant like police gets
Mhm.
after a crime has been committed.
Okay. Okay. What is the actual difference between an FIR and a complaint?
FIR is primarily being done by the police, and
Mhm.
a complaint is given to the magistrate.
Mhm. Mhm.
Any person who thinks that a criminal act has been done against them,
Mhm.
they will approach they'll approach the police and or the magistrate.
Mhm.
So once the person who goes to the magistrate gives gives anything in writing which amounts to a criminal thing, then that will be considered as a complaint.
Okay. And what about to the police? Like if you go and you have to make a complaint?
I give look the, if I go to the police and give them the complaint, they'll first see whether this is a cognizable offense or not. There are certain ingredients which
Mhm.
has to fulfill, because look, in India where we live,
Mhm.
people just to harass a person
Mhm.
will go and file a complaint with the police.
Sure. Yeah.
So police have to be very cautious while registering an FIR. Anybody can go and report a complaint, maybe that look, I was traveling
Mhm.
and on the way I dropped my wallet which has my driving license. So
Mhm.
the driving license authority will not issue me another driving license till I have a complaint or the FIR. So for that I have to go and submit a complaint.
Mhm. Mhm.
That cannot be done with the police, the magistrate. So, but to avoid the harassment which is being caused by few people,
Mhm. Mhm.
police are very cautious while registering the complaint or converting the complaint into an FIR.
Okay. I understand. I understand. So in what circumstances can a FIR be quashed by a high court?
FIR can be quashed by High Court in various forms.
Mhm.
But before I answer this, I have a very interesting thing. I want to share that because you were discussing about FIR. Now
Mhm.
there is a concept of zero FIR also.
Okay. Mhm.
Zero FIR, because FIR is being registered only where the crime has been committed.
Mhm.
Earlier, the police people were a bit, they were not inclined to register the FIR, which was for the crime which was committed beyond their jurisdiction.
Mhm.
However, after the Nirbhaya case,
Mhm.
the
Mhm.
Ministry of Home Affairs came with a direction that with the concept of zero FIR,
Mhm.
where any police station, all police stations are bound to register the FIR as soon as the information is given to them.
Mhm.
Thereafter, they will transfer the FIR to the jurisdiction where the matter lies.
Okay. That makes sense. Okay. So no matter which jurisdiction, police station you're approaching, they would be registering your FIR in case there is such.
Such a crime, there is a cognizable offense,
Mhm.
then it's that their duty to register the FIR.
So what qualifies as a cognizable offense, as you've been mentioning?
Cognizable offense is the offense where
Mhm.
police can arrest a person without warrants,
Okay.
or maybe, or you can say that without court's interference, they can go and arrest a person, like dacoity,
Mhm.
murder,
Mhm.
rape, theft. These are cognizable offense, an offense which has been committed against the society.
Okay. Okay. Okay, that makes sense. So there is no, so if it's a cognizable offense, then even the person who has filed the charge doesn't have the right, for example, to withdraw that because it's an offense
No,
against society in general, not against an
correct,
individual, right?
correct, correct,
Okay.
correct. That is why in India we see that these days the money, the cases where the money siphoning of money has happened,
Mhm.
everybody is interested because some ex-bank might have filed a case, but now it's beyond their control that they can't withdraw it because that crime was done, actually committed against the society.
Hmm. I understand. That makes sense. Okay. Going back to the question that started this, in what circumstances can the FIR be quashed by a high court?
Look, High Court can quash the FIR where it thinks that it's a complete abuse of process of law.
Okay.
Maybe some ex-person has filed a complaint against Y. However, the circumstances, evidence, something XYZ things are not in favor of the
Mhm.
victim.
Mhm.
But however, an FIR has been registered. The person, the so-called accused, is facing their trial or is being called by the police for investigation. He can go to High Court under Section 482 and file for a question of that FIR.
Okay. Okay. Okay, I'm going to ask a different question now. What is the difference between a compoundable and a non-compoundable offense?
If X says, okay, I have no grievance against Y, he has compensated me. For example, there's an accident. There might be a police case, but X says, no, no, I don't want to go into that. He has taken care of my vehicle and has given me proper medical facility, so I don't want. So that is a compoundable case. The case which the victim himself can withdraw.
Okay, okay. That makes
It's
sense.
more elaborately defined in section 320 of CRPC.
Okay. So what does a charge mean, and what are the essential conditions which constitute a charge?
Charge basically means the precise formulation of a specific acquisition against a specific person.
Okay.
Like example, if a person has gone for a robbery, assumingly, but while doing a robbery, he trespasses also. He made a person grievous hurt also. A person is also grievous hurt. Then he has tried to murder also. So when a charge is formulated, it's basically against a one person, but there are different charges
Okay.
that he has committed so and so crime X, Y, Z. All these crimes he has committed. These all those things will formulate to say that a charge has been framed against him.
Okay.
What are the essentials of the requirement of a charge? I'll tell you. It must state the offense of the crime committed by the accused. If the law creates the specific names of the offense, that has to be specified. The charge sheet must define and explain the elements of the offense on which the accused has been charged with.
Okay. I understand. That makes sense. Okay. So another question on this same topic is about bail. Okay. So what is anticipatory bail, and under what circumstances can anticipatory bail be granted?
Look, anticipatory bail is a concept where a person thinks, or any person can think that look, such a situation is in changing, and he apprehends that he might be arrested for something. He can go to court and say, look, I have so much apprehensions that I might be arrested. So please grant me anticipatory bail. Anticipatory bail is a bail, in simple words, it's a bail which is being granted to a so-called accused before he is arrested.
Okay. Okay. Ashu, right now I'll just go back to a couple of questions which I think I missed in the middle, which I'll just cut, copy, paste, and add them. Okay.
Sure,
So,
sure, sure.
so on the same topic, I'd like to ask you, what is bail, and why is it given, and in what circumstances is it given?
Bail is a statutory right of any accused. The bail can be given on various grounds. One is if the court thinks that the person who has committed a crime, obviously a person who has committed a crime will be arrested and will be seeking for the bail. The person who has been arrested, all evidence has been accumulated, all evidence are with the investigating officers, and there is no need, and he will not hamper with any evidence, bail can be granted. If the court thinks that, look, no, the court has suspicions that, look, he has not done this crime, somebody else must have done, bail can be granted. Then comes a question that statutory bail. That is another question. Statutory bail is that if a person has been arrested and he might be arrested for an offense which is up to 7 years or more than 7 years, the investigating officer is obliged to file the charge sheet within a stipulated time. For 7 years, the stipulated time is 60 days. And for the crime which is above 7 years, for the crime for which punishment is more than 7 years, the stipulated time is 90 days. If the investigating officer fails to do that, and the accused person on the right time files for the bail, courts are bound to give them bail.
Okay. Okay, Ashu, thank you so much for doing this. This has been most insightful and very interesting for people to watch. We hope to see you again on this webinar.
Sure. Thank you so much.